that's okay.
And the second point was, what I found is that when people referred, I always ask them where they're up to in their complaints procedures, etc. But after I spent quite a lot of time, then I always get the bombshell of, oh yeah, but I've got a restraining order on me, or I'm not allowed to leave the country, or I've got some kind of warrant for arrest outstanding on me. It's those little bits that, and I always say to them, you have to be upfront and honest about why your kid's been taken away from you. And when I get to the point where we can sit down, go to court and fight your battle, that's when I say, yeah, but there's a warrant for my arrest if I go within 500 yards.
Yeah, but there are, like the Charles Roy Taylor saga, where Charles Taylor was locked up for 20 months for talking to his grandson.
Yeah.
Right? Now, most people know about this case. Yet I don't blame Charles Taylor at all. I have no criticism of Charles Taylor.
I don't, think any badly of them. But if they tell me up front,
no,
like I say,
you need to know the whole story, right?
And that's the biggest problem that I've had all the way through. They're not telling me the full story.
There's a danger that we're talking about individual experiences, and there's only a certain amount of time. We've just had two rather important points put forward concerning the forms that he can get on Word, and the other point has just been made by the lady. Could we not, at this moment here, just establish, because it would be rather easy for us, we can then move on, in the event that we had certain questions about certain technicalities, could we get certain date and points that we could contact for information? That's what we don't have, and we each end up talking about the same things. And
so what it is we're going to produce documents after both of these meetings, and Ian was at the meeting yesterday as well, we will produce a document with all of this in, but also we'll put it on the website, so that you've got, if you need to look at law, look at statute law, don't look at OPSI, things like that. But it's things that we're picking up. That's why Emily's taking notes. Emily's trying to keep notes of everything, and we'll try to pull it all together and email it out in about a week's time with as much as we can in it.
I've got to mention a very good situation happened last week, and this was with Judge Bloom. The local authority solicitor tried every which way to make sure that I couldn't go into court, and in fact he stood there and told me that in no way was I going to be allowed to speak in this court, very intimidating at me. And I said, well, that really depends on the judge. I've been able to speak in other courts, it's up to you, it's up to the judge. And when the judge came in and explained who I was and said, and she's from Justice for Family, really down the Justice for Family, and Judge Bloom actually turned around and said, oh, Justice for Family, she said, yes, I've been on the site, and I have absolutely no problem with Chrissy Young being here as emotional support for the mother, as this support, as that support, and it isn't about, it's about procedures, and I have no problem with this type of thing that's going on. And the local authority's jaw that went, and he went, and I fully approve Christine Young to be Mackenzie friend. So
it's working. Right, but moving on from the technical organisational side, one of the critical things is getting things into the public domain so we can talk about them. Now, obviously, Simon Clayton's broken down. He's not going to be here, by the way. But Clayton v. Clayton actually had quite a bit of an impact on issues once proceedings have come to an end, such that although you can't talk about what's happened in front of the judge in private, you can identify the parties concerned, but then again you get a gapping order put on you once you've done it, as we know. But there is another issue, which is this, is that parliamentary proceedings are only accountable to Parliament, they're not accountable to the courts. That's actually Article 9 of the 1688 Bill of Rights. Okay? If you look on my website, you will find a petition relating to a Richard Pullen. And in that petition, it was looking at the issue of capacity that I'll come into in a few moments. that, without going through parliamentary proceedings, would have been a contempt of court. It's actually a very important issue, which is why it was put into parliamentary proceedings. Now, putting things into parliamentary proceedings isn't that easy, but it's not that difficult either. There are special forms of words. I've been using petitions to do that, a parliamentary petition. You need to get either the agreement of the constituency member of parliament that another member presents it, or you need to get the constituency member of parliament to present a petition. Right? But I'm using that technique to highlight things like how stupid Section 31's interpretation can be. Right? The capacity issue, which I'll come to in a bit, and other things as they crop up. So if you take home education as an issue, you can put that into a parliamentary petition. It then appears in Hansard, and people can then talk about it. It's all well and good saying you'll put all your papers up on a website based in Northern Cyprus, on the hope. And it doesn't work entirely, because if Jack Straw visits the country, you can get arrested even if you're in Northern Cyprus. Anyone's heard of that story? That one will get in the public domain through a parliamentary procedure soon. That part of it isn't covered by contempt anyway. But the fact is that you can't talk about it in the British media. But if it's a parliamentary petition, you can talk about it in the British media, as you will see from an article in the Nottingham Evening Post related to Rachel Pullen's case. Now, coming into that case, having mentioned that that is a way of getting things into the public domain, this was about capacity. The capacity to issue proceedings and to litigate. Between the 1st of January 2006 and the 22nd of October 2007, there were 340 adoptions that went through where the parents were told they were too stupid to say no. Alright? That's a bit more extreme than you normally get. I have a difficulty explaining to people what actually happened. What happens is the local authority instructs an expert who says that you don't have the intellectual capacity to instruct a solicitor. The official solicitor comes in and doesn't contest the case. Now, this is going to blow up. I'm going to make sure this blows up, and I'm in communication with Alistair Flipolado, who is the official solicitor, about what his staff have been doing. All right? I'm particularly looking for other cases where the same thing has happened. I know there are cases, and in practice it's very clear from the paper. There was a Court of Appeal case in 2002, which is on the paper here, Masterman Lister versus Bruckman Company, and it's very, very clear what mental capacity is needed to instruct a solicitor. In fact, it's the mental capacity to understand what it's about. And if you know the case is about having your child taken away, you have the mental capacity to instruct a solicitor, and it's as simple as that. Yet, time and time again, people are excluded through the experts, and that's point 3 on the note. I am particularly looking for mental capacity cases, because what I want to do, and I'm close to moving to Rachel, is to get these people talking on the telly, making it clear that they do have the mental capacity to instruct a solicitor, whilst actually in the courts are deciding they don't decide.
I know of a case in Plymouth where the parents were forced to be seen by a psychiatrist, otherwise they wouldn't have contact with the children. And the psychiatrist went without their consent and made all sorts of discrepancies, and this is going to be looked at and being brought to the attention of the courts again. And there's 5 children involved, and they've been trying to push for adoption, at least 4 of them. And I've been just thinking, this is what it's about.
That's what it's about.
Yeah.
Official solicitor. And this is why this is, that's why I put those words on this piece of paper. On my blog, I have 2 main websites, John Henning Lane and John Henning Blogspot. On the blog, you will find an entry related to mental capacity, which links to the British and Irish Legal Institute's original record from the Court of Appeal relating to Masterman, Lister and Bruckman. But I've extracted from that the key part of it.